Morning, everyone. The purpose of my presentation today is exactly what the title is that human rights and accommodations are something that a lot of employers have problems with. Well, not so much problems, but sometimes have a hard time grasping and understanding. And really, my presentation today is just a high-level overview, walking you through the process. Um, yeah, a little bit about myself. Angelica had already introduced me, but I am a management side employment lawyer. I represent employers in anything that involves the workplace: hiring, firing, human rights, workplace investigations. I assist in the employment aspects of corporate transactions, and on occasion, I will represent employees. But 90% of my practice is devoted to 95% of my practice is devoted to representing employers. And yeah, I represent large employers, medium sized, small owner operators, companies that have HR departments don't. But one thing that they all have in common is that sometimes they have a little bit of difficulty with the human rights regime. So we live in a society, that a generation ago is our society today is a little more tolerant. We have a stronger understanding of items like mental health, substance abuse issues, LGBTQ plus identity, and other items that we just didn't have the knowledge before. And even though we've made a huge progression as a society, employers will often make mistakes when it comes to certain human rights and accommodation issues in the workplace. And I want to say 99% of the time, they don't make these mistakes out of spite or prejudice, but it's just out of a lack of knowledge about how to properly address these issues. And the goal of my presentation today is really to get everyone thinking a little bit more about how to properly accommodate and deal with human rights issues in the workplace. And the reason we need to pay attention to these items is twofold. Number one, human rights claims are expensive and can drag on for years. The Human Rights Tribunal in Ontario is incredibly backlogged, and claims that are started today, you might not have a hearing for 4 or 5 years. There might be evidentiary issues, there might be motions, and it's really a large cost expenditure. And unlike the civil courts regime, the Human Rights Tribunal does not award costs. In Ontario, in the civil courts regime, there's a loser pays, in which the losing party pays a portion or all of the winning party's legal fees, depending on certain factors. But I always say the Human Rights Tribunal is a free kick at the can. So an employee who feels they've been slighted or wronged, they can have their day in court. So really, it's not a scenario in which if it's a baseless claim, you'll get your costs. You'll have to incur those, but so will the employee. And the second reason is workplaces where people feel respected, they tend to be more productive workplaces. If someone feels that they're being slighted or discriminated against, maybe they don't give 100% effort. Maybe they have one foot out the door. Maybe they take it out on their coworkers or their superiors. So if we can create workplaces where people feel that their rights, whether it's based on gender, age, I'm going to discuss some of these more categories in a little more depth. If they feel that they are respected, I think there is a stronger chance that the workplace will be more productive. So, what is the Human Rights Code? So, the Human Rights Code, it's the legislation setting out the human rights framework in Ontario. It was first brought into force in 1962. It was one of the first human rights legislations in North America. So, within the code, there are all sorts of areas of where it applies. Now, but today we're really only going to deal with employment. So the code provides every person with the right to equal treatment in employment without discrimination or harassment because of the following protected grounds. There are a lot of these, so I will go slowly. So we have race, ancestry, place of origin, color, ethnic origin, citizenship, creed, sex, sexual orientation, gender identity, gender expression, age, record of offenses, marital status, family status, or disability. Now, many of these seem fairly obvious. It makes sense you can't discriminate against someone on the basis of sex or gender or place of origin, race. But one that people have tremendous difficulty with is disability. So, what counts as a disability? The code defines disability as the following: any degree of physical impairment, mental impairment, developmental disability, learning disability, mental disorder, or an injury for which WSIB benefits are claimed or received. So the code prohibits discrimination based on any of the above noted protected grounds. So discrimination is not specifically defined in the code. There are a few different forms of discrimination that have been recognized. So I'm going to walk you through some of these. So first, direct discrimination. This refers to a scenario where an employee adopts a rule that is consciously discriminatory by treating a person differently because of a protected ground. So, for example, if an organization states they don't hire individuals who are not from Canada. And I find direct discrimination tends to be the rarest ones because most people, again, we live in a much more tolerant society. No one is going to, unless they specifically want to, directly discriminate against someone. So the other forms are a little bit, it's less black and white and it's a little more gray. So indirect discrimination. So what do I mean by that? It refers to a situation where another person in an organization is just where another person is discriminated against by indirectly treating a certain person differently. So if a hiring manager tells a recruiter not to schedule interviews with people who have a disability because they may require more time off, or not hiring a parent because they may need flexible working hours to spend time with their children. So the next one is systemic discrimination, and this occurs when a workplace requirement or policy appears to be non-discriminatory, but in practice it excludes certain individuals. So, for example, a workplace rule that requires all employees to work every Saturday may be discriminatory against individuals who attend a religious service on that Saturday. And the final one is discrimination because of association. Now, I find this one also can be quite rare, but this occurs when an individual is harassed or discriminated against because they are associated with a person who is covered by a protected ground. So, for example, a worker is not promoted to a role because they're friends with another employee who's a member of the LGBTQ plus community. So now that we've kind of walked through discrimination, we're going to sort of discuss the duty to accommodate, which is really sort of where this comes from. So, what is the duty to accommodate and how does it arise? So, in the workplace, the duty to accommodate arises when a neutral rule has a discriminatory effect on an individual due to a protected ground, or the rule on its face discriminates against individuals due to a protected ground, and the rule is not a bona fide occupational requirement. And with respect to bona fide occupational requirements, I'm going to touch more on that just a little bit later. So the employer's duty to accommodate, there are two. Oh, I skipped a slide. My apologies. The bona fide occupational requirement, again, I'll touch on more on that later, but the duty to accommodate has both procedural and substantive obligations. So when it comes to the procedural aspect, it requires an individual investigation of accommodation measures and assessments of the employee's needs. So if a worker needs accommodations, the worker and the employer should discuss how a worker is going to perform certain functions of the job. So, for instance, job functions a worker could perform with these accommodations include accessing the workplace or workstation, communicating verbally or in writing, maintaining focus, organization, or energy level. So the worker and the employer should list the tasks that the worker performs differently, identify all job functions involving these tasks, list the accommodations that would allow the worker to perform each function, and finally, outline strategies for implementing these accommodations. So the substantive obligations involves an analysis of the reasonableness of the accommodation offered. So once an organization has recognized the need for a specific accommodation, they must take steps to implement it. So once you've dealt with all the procedure, you have to put into action. So what are some of these examples? So installing a ramp for someone with a physical disability, flexible hours for a single parent to be there when their kid gets home, or downloading a screen reading software on the worker's computer for someone with vision issues. And there are tons of options when it comes to accommodations, and there's no one size fits all scenario. So we can do things like assistive devices, ergonomic equipment, modified shifts, reduced hours, flexible schedules, and additional training. It just really depends on the disability. And both these components are essential to the duty of accommodate. And to understand this a little further, I'm going to walk you through a case from the HRTO, Jiang and DBG Canada Limited. So this is a 2021 case. So in Jiang, the employee had a heart defibrillator implanted in his chest and was cautioned by his doctor to avoid exposure to high voltage machinery. The employee believed that certain equipment in his workplace presented a risk and was provided an accommodation, allowing him to work in an area separate from this equipment. After a period of time, for some reason, the employer decided to revoke the accommodation and they terminated the employee for refusing to work near the equipment. So, close to a year after terminating the employer undertook a workplace assessment to investigate whether or not the equipment posed an actual risk to workers with cardiac devices, such as defibrillators. The resulting report found that there was no risk, meaning that there had never been an actual threat to the employee. So the worker commenced a claim for dismissal and for human rights damages. And in this particular case, the tribunal took issue with the fact that the employer failed to ask further questions to better understand the doctor's request. The employer had assumed that the accommodation was not justified after speaking to some of its staff to confirm the voltage. This information alone, as it turns out, was irrelevant. And in order to form a proper opinion, the employer would have needed to take field measurements. So, by delaying the audit of the workplace, the employer was in a position where it did not have the information necessary to support its position that the request was unreasonable or unnecessary. The procedural duty here, at a minimum, was seeking out information about the safety of the workplace for the employee. And they failed to do that. And by failing to do the procedural duty to accommodate, they never met the substantive duty to accommodate. And the tribunal ultimately concluded the employer had failed to meet its obligations under the duty to accommodate. And the tribunal awarded the employee compensation for lost wages, in addition to $20,000 for injury to their dignity, feelings, and self-respect. So this case in Jiang really it's a great case to let us know when employees need accommodations, even if it and I'm going to discuss a little bit later on the limits to those accommodations. An employer needs to seriously take into account what the employee needs to do the job. So I had discussed previously bona fide occupational requirements, BFORs. And what are these? Essentially, they're adopted for a purpose connected to the job, and the rule is necessary for the legitimate job purpose. And employers will often establish standards or policies without any intent to discriminate. But these standards can unintentionally produce adverse discriminatory effects. So, for example, instituting a physical requirement for a job without considering actual job duties may disproportionately affect individuals with protected grounds. This unintended impact can still be viewed as discriminatory and potentially lead to legal challenges under the code. So, one of the most instrumental cases involving BFORs comes from the Supreme Court about 25 years ago. So, in BC, Public Service Employee Relations Commissions and the BGS and the union, BGSEC, BCG SEU. So an employer fired a female firefighter because she couldn't pass the minimum physical fitness standards. And the Supreme Court found that although the minimum physical fitness standards were established in good faith, without any intent to discriminate against the employer failed to prove that the standards were no more than necessary and that the employee who failed the test would pose a severe safety risk to herself, her colleagues, or the general public. So the termination was ruled discriminatory and the employee was reinstated. So if an occupational requirement is not a BFOR and it has discriminatory effects, there's always the potential for a court to strike it down. So the way I kind of view this case is that it's okay for a business to have bona fide occupational requirements. I mean, I think about a trucking company and having, someone saying, well, my vision is impaired. Can I still drive the car? Or can I still drive the trucks? And for that one's a little simple in terms of a BFOR, because to be able to drive, you need a valid driver's license. And to have the valid driver's license, you need to be able to see. So that might be a scenario where a court would say, well, vision is a BFOR. And in this firefighter example, maybe if the physical standards were not so high, again, I don't know them offhand what they were specifically. I don't think the case law divulges into it so much. But if there is a BFR that could be discriminatory, such as this one, if the standard was a little lower, it probably would have held up. But from the other side, you can see from an employer's view that they may have certain standards, but maybe the standard might be a little bit too high. So when you're coming with bona fide occupational requirements, you really should be doing an analysis of, is this required for the job, or am I using this almost as a filtering mechanism? So you have to really sort of take into account what these occupational requirements are, and is it possible to do the job without needing all of them? And if it is, you should probably think about changing up the mechanisms. So this topic I'm going to touch on now, undue hardship, is a conversation I have with clients weekly. Someone will say to me, hey, Jordan, I have this employee who's claiming they have X disability. I don't want to accommodate. What can I do? And my answer is, I usually explain to them what undue hardship is. So we have to accommodate employees up to the point of undue hardship. The code does not define what undue hardship is. There's no specific definition, but undue hardship is usually viewed as the limit of an organization's capacity to accommodate without experiencing an unreasonable amount of difficulty. And like I said, there's no precise legal definition, nor is there a standard formula for determining undue hardship. Each situation is unique and should be evaluated individually. So organizations uncovered by the code have a duty to accommodate to the point of undue hardship. Some degree of hardship may be expected. It is only if the hardship is undue that the accommodation will not need to be provided. And in many cases, it won't be difficult to accommodate a person's disability. Someone who has back pain can get them an ergonomic desk. An office worker with, vision issues, maybe you get them a screen reader. But a lot of times, sometimes the accommodation is a little bit more difficult than that. So accommodations, like I said, they may simply involve making policies, rules, or requirements more flexible. And while doing this, it may involve some administrative inconvenience. Inconvenience by itself is not a factor for assessing undue hardship. So the code prescribes only 3 considerations when assessing whether an accommodation would cause undue hardship. The first one is costs. Costs will only be an undue hardship if they are so substantial that they alter the essential nature of the enterprise. And the way I always like to say this a little more colloquially to clients is, you essentially have to accommodate to the point where the company can essentially no longer stay in business. And that would accommodating this employee change provide be so expensive that we would entirely change the nature of the organization. The second point is outside sources of funding, if any. So, for example, are there outside organizations who can help subsidize the cost? And an example of this would be, for example, a lawyer who's deaf and they work for a law firm and they receive real-time captioning or a sign language interpreter funded and provided by a court. When the lawyer is acting in court, court takes responsibility for the duty to accommodate, relieving the lawyer's employer of its responsibility during this time period. The final one is health and safety requirements. So, if any, is the accommodation going to result in serious risk of any sort of health and safety issue? So, for example, like I said before, with the employee who's the truck driver with bad vision, is the fact that they cannot see, will that cause health and safety risks to themselves, to the general public, to their coworkers? So these are the only things we take into account. It doesn't matter if it's inconvenient for the business, if it annoys other employees, or it has an issue with customer preferences. These are the only things we take into account. And the nature of the evidence to prove undue hardship must be objective, real, direct, and in the case of costs, quantifiable. So we need unambiguous evidence to say this will be too difficult to do. The organization responsible for the accommodation must provide facts, figures, scientific data, financial information to support a claim that the proposed accommodation in fact causes undue hardship. A mere statement saying, "Oh, I can't do it, it's too hard," without supporting evidence, or that, "Hey, this is too high or too risky," based on speculation or stereotypes, won't be sufficient. And again, undue hardship is where a lot of people will go wrong. It needs to be a scenario. This is where a lot of employers will get in trouble on undue hardship, and that many people just they don't understand the full extent that undue hardship. So, the next sort of thing is I'm going to run through some cases about the costs of non-compliance, and then the first two, and then the last two cases here are situations where the employer was successful. So I'm going to, in case, I'm going to jazz it up, but if case law is not your thing, I apologize in advance. So, as I said, attempting to accommodate employees is difficult. There's no perfect formula, but when an employer refuses to accommodate, the financial burden of non-compliance can be exponentially more expensive than complying with the accommodation. So in Hamilton Wentworth District School Board and Fair, a 2016 case that it was a human rights issue that was appealed to the divisional court and then to the Court of Appeal. The Court of Appeal upheld the decision where the employer was ordered to reinstate the employee, provide back pay from June 26, 2023 to the date of reinstatement. So keep in mind, we're talking over 10 years of pay, likely an amount probably over $400,000, less than the income and benefits she received, in addition to $30,000 as compensation for the injury to this employee's dignity, feelings, self-respect, and other remedies. And the issue in this case was on the basis of illness, on disability due to a chronic illness. So rather than try to accommodate the issues, which again are very difficult, I have lots of sympathy for employers in the dealings of accommodations, because sometimes the employee may not want to play ball and they may want the sun, the moon, the stars, and not something that's a reasonable accommodation. But when faced with an issue of this, would you rather deal with some frustration than spend $430,000 on wages and damages plus legal fees, and especially this was appealed to the civil courts, court costs? So keep in mind, This can be incredibly expensive. Now, a lot of times in human rights claims, the employer will be named, but individuals who work for the employer will be named as well. And in this case, in Halliday, um, a personal respondent, the employee's manager, was found to be joint and severally liable for the damages. So in Halliday, there was an employee who had been sober for 8 months before he started working for his employer, but he had spent 20 plus years prior battling addictions to crack cocaine and other drugs, and he attended numerous residential addiction recovery programs over the years. So he was sober for the duration of employment, and he starts his new job. So the employer first became aware of his addiction early on in his employment when his manager asked him to go out for a drink after work. The employee declined the offer and explained that he was a recovering addict. The, and the employee has a setback, and he tells his employer about the setback. After his relapse, the employee requested payment from his employer of some outstanding commissions. And when he requested payment, he was advised he would not get paid until he checked himself into a detox program. His employer went so far as to lure him into his car with the promise of going to a bank machine to pay him, and then attempted to force him to enter a rehab facility. I know this sounds like the episode of The Office where Michael tries to take Meredith to rehab, but I promise you this happened. So the situation further deteriorated when the employee was called a effing crackhead by his employer during a telephone call when the employee was attempting to discuss the reasons behind the employer was trying to say why the commissions remained unpaid. And the employee gave evidence that, when he was called a crackhead due to his relapse, he had been sober at this point for a few months. He felt as if it was a slap in the face. And later the same month, the employee learned that his employer sent an email to other employees stating that the employee was suspected to have been stealing for months and is a former crackhead. The employer also contacted some of the employees' business contacts and told them that the company was contemplating possible legal action against the employee. And the email referred to the company having worked with the employee to curtail his crack addiction and help him into rehab. So the employee resigned from his employment and commenced a human rights claim. So the employee was awarded damages in the amount of $25,000 from his right to be free from discrimination in the workplace, as well as compensation for injury to his feelings, dignity, and self-respect. And the tribunal found that the employee's resignation from the company was a direct result of the treatment he received from his employer and the manager, and he was also awarded damages for lost wages for 3 months following the end of his employment. And the personal respondent, the manager, was found joint and severally liable. So he had to pay. He and the company were both on the hook. Now, a lot of times when I deal with human rights claims, sometimes an employee will name everyone, and then we have to bring a motion to the Human Rights Tribunal to have the personal respondents who are named in the application removed. I'm not going to walk you through the legal test of that because that's a little bit dry. But keep in mind that in certain situations, a personal respondent, whether it's a manager, a coworker, can be liable for the same damages as an employer. Now, I've kind of potentially scared you all a little bit with some of these cases. So this one is a little more employer friendly. So not all requests for accommodations need to be granted. So in My Stitch and Value Village, again, the facts in this are relatively straightforward. The employee she was a cashier at Value Village, and she was diagnosed with a repetitive strain injury. So the employer accommodated her by moving her to a less physically demanding retail position. However, this new position required the employee to work evening shifts, which conflicted with her obligation to care for her elderly mother. The employee's request to have her elder care commitments accommodated led to a back and forth with Value Village. The employer wanted evidence that no reasonable care alternatives were available, and the employee provided none and failed to show up for her scheduled shifts, to which the employer terminated her employment. And at the tribunal agreed with Value Village in that Value Village made reasonable attempts to deal with the accommodation. They asked her, are there alternatives available? And the employee refused to play ball. She refused to engage in any discussions with them because, for whatever reason, she did not want to work evenings. So this case, is a reminder to employees, or employers, my apologies, that the employees also need to play ball. If you provide a reasonable accommodation and they don't provide and they are unhappy with it, but they don't provide evidence as to why they can't deal with that accommodation, and again, in this situation, this employee didn't show up. If that scenario occurs, I mean, every single case is obviously different, but there's something to be said that if you try and play ball and the employee refuses to even get on the field, you might have a chance to be able to terminate them. Now, like I said, sometimes these HRTO claims can be baseless. So the HRTO can allow employers to bring a motion and ask for a claim to be dismissed if the tribunal finds there's no reasonable prospects of success. So in Laux, the employee took a number of medical leaves of absence during her employment, and ultimately, she applied for disability benefits. So she had a claim approved for a few months, and she returned to her full-time duties. So about a month or two after she returned, she was seen by other employees stealing food from the company cafeteria, and the company terminated her employment for cause. The employee alleged in her HRTO application that she suffered from PTSD and requested a loan from the company to assist her during the transition period of return to work. She said that returning from her disability leave left her broke and destitute, and that the company would not advance her any money, so she started stealing from the cafeteria to survive. And the employee also said she was discriminated due to having bipolar disorder. And the company's view was that her employment was terminated for cause for the theft, and there's no breach of the code. So the employer brought what's called a summary hearing and said that the application had no reasonable prospect of success. And the tribunal agreed with this position. In reaching the decision, the tribunal reiterated that the application must allege sufficient facts to establish a breach of the code. And one of these breaches, it's one that covers the allegations made, which, if they are believed, is a complete and sufficient to justify a finding in the employee's favor in the absence of an answer from the respondent. And the tribunal found that a strong case is not met simply alleging that you are treated unfairly, because the code does not provide a remedy for general allegations of unfairness. The tribunal said there must be a basis beyond mere speculations and accusations to be believed that an employee could show a breach of the code in order to continue in the tribunal's process. And the tribunal finally stated that in order for an application to advance to a full hearing on merits, the applicant must point out some evidence beyond their own suspicions that could make out a link to the code. So no matter how strongly believed an employee's view is that they were discriminated against, if there's no evidence, the tribunal is not going to be able to find that discrimination has occurred. So, the case law I've presented here, it's to show you kind of both sides in that, there are high financial penalties for noncompliance and for discrimination, but there's also recourse to an employer for trying to, deal with the process correctly or to deal with these baseless claims. So that's the full extent of my presentation here. I think we can move on to the question and answer session. But again, I want to reiterate, accommodations and human rights in the workplace. The purpose here is not to punish an employer, but it's to have an employer help employees deal with issues in the workplace in order to make a more productive workplace. An employee who feels that their employer is going above and beyond to try and accommodate them will probably be more loyal to the company. This also will protect you from potential liability with the Human Rights Tribunal. So again, I can put my email in the chat, but if either you or your organization have questions about how to deal with accommodations or human rights issues, I'd be more than happy to have a chat. And I think we can facilitate the question and answer period now.